For CISSP purpose, you need to know 4 types of investigations, which are criminal investigation, civil investigation, administrative investigation, and regulatory investigation. Let's first see how criminal and civil investigations compare. In all cases, the person who has been accused is called a defendant, who is considered innocent by the court until proven guilty. The court will not declare you a thief just because someone filed a charge against you. If you file a charge against someone, in criminal cases, you would typically be called the complainant, while in civil cases, you would be referred to as the plaintiff. A criminal case involves legal proceedings initiated by the government against an individual or entity accused of committing a crime, while a civil case involves a legal dispute between individuals or entities seeking compensation or resolution for a non-criminal matter, such as contract disputes, personal injury claims, or property disputes. In a criminal case, once the complainant has reported, the party who initiates the legal proceedings is often referred to as the prosecution or the state or the people, depending on the jurisdiction, which is a professional term for legal systems. As we know that until proven guilty, a person is innocent, there is a burden on the prosecutor in case of criminal cases, or the plaintiff in case of civil cases. This is formally termed the burden of proof in law. Proof needs to meet certain standards. In criminal actions, the punishments are stricter and harsher. So, we need to be beyond a reasonable doubt that someone is guilty. Evidences have to be clear so that the judge or the jury has no reason to think that the defendant is innocent. The standard is lower in civil cases. Criminal cases tries to decide if the defendant is innocent or guilty, while civil cases decides if the defendant is liable or not. Civil law governs relations and interactions between private entities. In civil cases, if the judge or jury thinks that there is 51% or more chance that the defendant is guilty, that's sufficient to prove guilty. This is called preponderance of the evidence. During investigations, court might place injunction notice, which is a court order requiring a person or entity to either cease doing or else start doing some specific action. Court might also order the relevant parties to attend the court. Such document is called a subpoena or a summons. Courts can also issue different types of warrants, such as search warrants and arrest warrants. Let's now see what's an administrative investigation. In some ways, this is similar to civil investigation, as the defendant is being proven liable or not. These types of investigations happen within an organization. These are internal investigations. Someone violated an organizational policy but has nothing to do with any parties outside the organization. But administrative investigation has the potential to turn into either a civil or a criminal case. Management is considered law within the administrative realm, hence, the burden of proof is of the lowest standard. Management can choose what to consider as sufficient evidence of proof. Punishments can range from issuing memos and recording in HR files, financial penalties or fines, restrictions on certain facilities, or even termination. If the nature of misconduct appears to be a criminal activity, after confirmation of the fact, management might consider reporting to the law enforcement for further investigation and punishment based on criminal law. So, it's important to maintain the trail of evidence, or the chain of custody. Internal does not mean that it should be conducted any less carefully. If the chain of custody is not properly maintained, it can weaken the reliability and credibility of the evidence presented in court. Any effort to convince the court will be frustrating. Last on our list is regulatory investigation. Some aspects of it is like criminal investigation, others are like civil. Like criminal cases, this investigates if your organization complies with certain laws and regulations, and finds if you are guilty or not, and the one who raises the issue is a complainant like in criminal cases. If you remember, in civil the complainer is called a plaintiff, not a complainant. Let's check some example. EPA or Environment Protection Agency is part of the federal government, and they dictate certain regulations for your business related to the impact on the environment. You violate EPA, you break laws. But on the contrary, PCIDSS is a contractual agreement between parties who chose to comply. But again, GDPR is a regulation, it has it in the name, General Data Protection Regulation. Violate GDPR, you violate the law. The burden of proof in regulatory investigation is similar to the civil. Regulatory investigations require preponderance of the evidence. As this is a borderline between civil and criminal cases, although regulatory cases have restraining orders, fines, financial penalties, but yet can lead to stricter punishments like house arrest, or even prison for life based on how bad the violation was. The CISSP CBK mentions the following investigation standards in particular: ISO/IEC 27043, 2015. This recommends procedural steps for conducting security incident investigations. ISO/IEC 27037, 2012, which provides guidelines for handling digital evidence. NIST SP 886, titled Guide to Integrating Forensic Techniques into Incident Response. And NIST SP 800-101, Revision 1, Guidelines on Mobile Device Forensics. Please get some idea on these 4 standards, might be helpful in your professional life as well. We are close to the end. Legal advice from an expert or professional in the field might be the best option, instead of trying to conduct an investigation yourself. Thanks for your time, until next. And thanks for watching.